Welcome. This is the Domain Name Law Show. We do this every Tuesday, noon Pacific, 3 p.m. Eastern, where we talk about domain name law and other domain legal issues. We usually cover some news, and then we review some recent UDRP decisions. I'm Todd Ryan. I'm one of your hosts. There's three of us. Jeffrey Neuman and David Michaels are my co-hosts. Hi, Jeff. How's everything going with you today?
Everything is good. It's a nice day here. I can't believe it's September, and it is. Yeah, so it's now well, technically it's not the fall, but now is the fall season, and at least for those in the northern hemisphere. So exciting times.
Yeah, I hope you had a nice Labor Day. My birthday's September 7th, and in the old days, it used to seem like it always fell right on my birthday. But it was obviously first in the U.S. First Monday in September, so that was yesterday. Everybody had a nice day off. Most people still work. But just so everyone knows, I'm in Los Angeles area. Jeff's in Virginia, and David Michaels is in the Toronto area. So we try to cover all bases. Hey, David, how's everything going with you?
All right. It's a little warm here today. It's like summer came back. It was gone for 2 weeks, but it's back with a vengeance.
Yeah, my family back in Indiana said it's going to be like 91 where I'm at today, but about 80, 81 back in Indiana. But it feels even warmer back in some of those spots because of the humidity. But yeah, so we got a lot to cover today. Get rolling here. If anybody wants to check out our show outline, you can go to DNL Show. That's domain name law. DNLshow.com and just click outline, or you can go to dnlshow.com/outline and you'll be right there. The few news articles I wanted to touch on today, all sort of legal related. The first one was a man sues GoDaddy 6 years after he says his domain was stolen. I know, you know, we're friends with GoDaddy. A lot of us have a lot of friends over there, and a lot of us use GoDaddy as a registrar and as a hosting company. But GoDaddy's not got completely clean hands. Sometimes when it comes to their participation or their part in lawsuits, Jeff, you've had to be, represent people that have sued GoDaddy and so on. What do you know about this case, about the guy who got his name stolen and why he waited so long to file this case against GoDaddy?
What do I know? I mean, just what I read. um, I read the case. It sounds, um, I should say, all that's out there is a complaint right now, so we don't know what GoDaddy's side of the story is. It's awfully late to file a case, especially since you're many years removed. I think what was it, 2019? Although he says he had a bunch of illnesses or not illnesses, surgeries that he was incapacitated, according to his complaint, that he wasn't able to file till now. Um, but if he's seeking the name back, that's not going to happen, right? That's just the ship has sailed on that one. Um, Whoops, I had an incoming call. Whether he can get damages or not, that's a whole other story. And it just depends on how true his accusations are. Uh, he he basically says that GoDaddy admitted that they lost control of the name, but I doubt that's the case. And then he says that that he provides all these things in there why he shouldn't have to follow the arbitration agreement and others. It'll be interesting, but there's no restraining order being sought, so the next thing you'll see is an answer. Um, or actually, no, the next thing you'll see is a motion to dismiss filed by GoDaddy. Um, so that would be due sorry, what is it, 14 days after the complaint. So we'll see in a couple of weeks.
Yeah, the domain name in question here, brud.com, Brud, and that was uh, a nickname that the domain owner, this gentleman out of Florida, was saying that's his name, Arthur Brud Porcher. But I was going to throw it to you, David, but ask you, okay, so he basically had this name for a long time. It was removed from his account, and he's like, hey, I didn't remove this. And then he, right, Jeff said he had some serious surgeries. And, right after the name was transferred out of his account, and, you're not always looking at your account. I don't know how many he had, but so this name was missing. He noticed it missing, but he had serious surgery. Then he tried to recover from that, had another serious surgery. And basically that was his reason for saying that's why I'm filing this now in 2025. That appears to be 6 years later. But in the meantime, he did do some other things to try to recover the name. Did you, oh, by the way, this was on dnw.com. I want to give them credit. That's where I saw this story. And you can see the link on our outline at dnlshow.com/outline, the link to Andrew Alleman's DNW story. But David, what did you, other little facts and points did you see in this case?
Well, what's the value of this domain name? It's Brud. It's not a dictionary word. I've never heard of it before, but maybe it's a nickname. I've only seen one business with that name and it's shut down and they renamed themselves. So I don't know if that was his business and he had to rename it. If so, then that would be adding on to his damages. But other than that, he's not going to get the name back. Under Arizona law, like the best he can do is negligence, and they're going to have to pay him for the value of the name and his out-of-pocket losses, if any. And that's about it. In terms of limitation periods, it's 2 years in Arizona for negligence, as far as I know. So, he has to prove to the court that he has exceptional circumstances that will help toll that limitation period. Now, he did say that he was working with GoDaddy as late as 2023 to get the name back, but that didn't work out. So
Yeah,
I don't know
Arizona's
how
kind
serious
of
that is.
unique in that he's not going to be able to even the negligence claim is going to be dismissed because essentially it's a breach of contract action. And in Arizona, as we learned, there's the economic loss rule that states that if you can't double recover, so if your claim is really a breach of contract, you cannot recover under tort theories. You can only recover under the contract. And so the contract basically, I'm sure GoDaddy will argue that the contract allows for a maximum of $10,000. Although he claims to have signed, he claims in 2019 that wasn't in the agreement. Um, I don't know, haven't done the research, but yeah, he's going to be limited as to breach of contract actions, and um, it's going to be an uphill battle for him.
Yeah, this name, he did, we all know Bill Hartzer, most of us in the room. He did reach out to Bill to try to help him recover the name, and I guess they filed a UDRP and lost it. I don't know if that was,
Well, that was weird because they said that Alexander said he couldn't find a UDRP. I haven't searched, but it was possible. And then it said something weird in the complaint, like it was dismissed because of timing. But there is no time constraint in the UDRP. So I haven't. Well, I'm on UDRP tools right now, so I'll look up Brud and see if there was ever a case. And nope, nothing on UDRP tools. So I don't know what he actually did.
and if a case is retracted or say they reach an agreement before they've assigned a panelist, I don't think UDRP.tools shows them. The reason I say that because I know when they're filed, it doesn't show. It only shows once it's been decided. But yeah, anyway, with this, so this guy filed his own federal lawsuit, it looks like to me. He filed his own lawsuit, which is already unusual. I mean, you make too many mistakes. You can't really, I've prepared them and showed it to somebody who said, listen, if you don't work with me, I'm going to, if you don't give me back my name, I had to do this one time, I'm going to have this federal lawsuit filed. But I would have certainly then connected with an attorney and said, here's what I've prepared. I hope this saves me some money. I hope you do it with me, you know, for no money. But so it's okay to help prepare your attorneys in a civil case. Okay. can do it criminal if you want to, but it's okay to help. But yeah, this guy went ahead and filed in a district court in Arizona this case that we're talking about. That you can see the link to dnw.com. But anyway, so this guy lost his name, brud.com, and apparently it not only did, now it looks as though whoever stole it, if in fact it was stolen, it was sold for like $9,300 on NameJet in 2021. So it got stolen in 2019. Looks like it was sold in 2021, and now it's sitting somewhere. And right, it looks like you're not going to recover this if you can recover any damages. And David asked, "What's it worth?" Well, last time it looks like somebody bought it in the open market. I mean, on NameJet for $9,300, which okay, that's pretty good, I guess. I mean, considering probably wasn't an end user buying it there. But all right, we're not going to go on to that. If interesting, if we know any more about what happens here, we'll share it with you. Before we get to the next story, I had a question to you guys. Okay, so if a trademark owner abandons their trademark here in the U.S., and when I say abandon, basically stops using it, and there's no indication that they're using it anymore. You search, you can't find anything. How long before it can be used by somebody else?
Well, it's a tough question, but presumptively it's 3 years. But if they have no registration, then presumably right away, just file your application and go for it. I filed applications and submitted petitions to cancel existing registrations that I knew were no longer in use because of amalgamations, and got them canceled because they didn't respond. And then all of a sudden, my client gets his trademark registered. So it works.
Yeah, I mean, it's you have to, a prima facie case would need to be established, which is that the mark has not been in use in commerce for 3 consecutive years, and then the burden would shift to the trademark owner to show that they have an intent to resume the use. Um, it's not very easy to establish. It's um, you know, it doesn't happen that often. That marks are abandoned, and and they succeed. But yeah, I mean, technically the standards are for, because it's pretty easy to show intent to resume. Um, but yeah, technically the statute says 3 consecutive years.
So if they vanish, then you're in better shape. But if they do appear, they can say, look, here, we had these issues come up, and I don't know, I guess a lot of things. It could be out of their control issues. Say if it's something like a governmental issue, somebody steps in a certain industry. I guess what I'm thinking is I remember one instance. Of course, if they say I don't know, maybe if they got new ownership or the company was sold, it was in a long escrow, and I don't know. I'm just coming up. So, bottom line, if they vanish, then you're in a better position. It's not. It's been abandoned. It's been over 3 years. They're not, claiming that they're going to do anything, or you just, they never come around. Um, no, interesting, because it happens more and more. I mean, people file, and people, companies are filing now. Like I said, now we don't get too many domain investors, or business people come into our rooms anymore and say, I just, I filed a trademark on my domain. It doesn't even make sense. It's like, what was the business? Like we all know, what was the class of business that you're doing? What is the product or service that you're offering? And then we'll get back to, um, the name that you plan on, trademarking, or yeah. I always liked when a lawyer didn't tell me, he was telling a group of people that, look at the end of your year when you see where your money's come from. If it's come from a product or service, well, then you might want to trademark that product or that service. And what was the name of that product or that service that, you know, um, generated that revenue. So usually, and it's like, so if you're an entrepreneur and you have, I don't know, a bunch of different products or a bunch of different brands, and some of them really haven't made money yet, well, you still want to keep track of all your information and all the money that you've spent, but you might have a half dozen. That doesn't mean you should file trademarks, um, you know, for everything. If you haven't generated any money, still keep track. You're trying to establish your mark, and it's much easier to file a trademark in your state, and that's cool. That's good too. It's, I guess, it's all part of establishing your mark. But if you really haven't generated any revenue from it, and it's not that you can't, show that. Just basically, I know for myself, you can't just file trademarks for every. Definitely ideas. Can't trademark an idea, even if you've named your friggin' idea. All right. The next news story, we'll get to these things fast. Intel wins LINUTRONIX.com UDRP. It was a domain gang article I have on the outline. But long story short is this guy um, registered the domain name on the day Intel announced their acquisition of this company. Okay, so Intel was going to buy this company over in Europe, Linatronics, I guess, and somebody registered the name and then offered and had it for sale for 32 million. And he said, I was got it because of, it's two words combined, some bullshit. And it could be, but the panelist in the case, and this isn't one we're reviewing, basically said, because you did it on that day, it's too fishy, it's too suspect, and offering it for 32 mil. So that's enough for us. That was the UDRP decision. I don't even know who the panelist was. I wasn't looking at it. Any Does that make sense, Jeff, as a panelist? I mean, geez, they buy it on
Yeah,
the day and then they offer it for so much.
absolutely. It's called opportunistic bad faith. Um, but this relates also to at least one of the cases we're looking at. Look, if you're going to make up a reason for why you registered the name, you need to have proof of demonstrable preparations, right? It can't just be an after the fact created excuse. And we'll see that come up as a theme in the both the, well, not necessarily the Dirty Harry one, but which one was it? It was, sorry, let me look at the list here. It was the Morgan Stanley one. It's going to come up. You have to show, you have to prove the demonstrable preparations. You can't just make up a reason for registering it. And the same thing with one of the other cases. I think it was Stephen Reinhardt may have done it, where they offered an excuse, and it just was like maybe that was the Dirty Harry one. Um, I'm getting confused with all the cases, but once we get into it, it does come up that you actually have to show demonstrable preparations to use it. You can't just make up an excuse. And there was one case we have today where the respondent ends up winning, but they all kind of looked at the excuse. I think it was the Jerry Levy. Yeah, it was the Dirty Harry one. They were like, "Come on, that's just none of us believe that that's really true." Uh, no, it wasn't Dirty Harry. Anyway, we'll get to it. I'll remember which one it was. But one of the ones the respondent created an excuse, and they didn't need to because they had already won on the fact that they had earlier rights. But they still came up with some excuse, but they didn't show it. If you're gonna respond claiming you intended to use it in conjunction with something, then you have to have proof.
Yeah, that
Some,
was the SRO case, but yeah.
but you guys got to cut us some slack too. I'm talking about the crowd. So many cases, and we talk about cases, offline with other people, and then we have our cases for the day, and you're like, trying to stay up on it. It is it's a challenge each week. But I mean, nothing, don't need any sympathy. Just cut us some slack. I was going to say, speaking of cutting us some slack, I'm trying to look through my comments. Some wise ass posted, yeah, I got a fucking, excuse my language. He said he's got a iPad, and for some reason he can't listen to on X Spaces on an iPad. And I wanted to say to him, but I didn't because I didn't even want to respond to the idiot. Was there's a lot of people that broadcast here on X, okay, and there's nothing we can do. Mess with Apple if you can't listen to an X Space. But anyway, on iPad, I don't care. That's on you. Find another way. But also, we do stream on YouTube. So this is being streamed on YouTube right now. I want to ask the guy, can your iPad listen on YouTube? But I didn't even tell him because I don't care if he listens or not. But I'm trying to find the guy so I can just call him out. But anyway, if you will to YouTube, I think you would go to youtube.com/trabc. I believe that's one of the ones. I got a couple on there that you could find it easy, but uh, youtube.com/trabc. Just in case somebody wants to listen. I did that because our friend Jerry Levine was like, he didn't, having issues listening live. If you're not an X, if you don't have an X account, you can't listen live to the broadcast, but you can listen to the replay if you don't have an X account. So I found that out working with Jerry, saying, yeah, Jerry, you can always listen afterwards. But anyway, so we do broadcast on YouTube too. We're big. We're big. And no, we're not on podcast platforms. This isn't, no one cares enough about anything. Okay. But, all right. So the next piece of news was real quick. I thought this was interesting, David. I wanted to get your take on this. So these states now, Michigan is the one that's in question here. I think it was a DNW article, but Colorado apparently has some laws already where, so no domains, you can't create a domain or subdomain that, or basically you can't use a domain or subdomain that includes a venue name, an artist name, or an event name to sell tickets. So for example, right, Snoop Dogg United Center dot whatever your ticket, crazytickets.com. They're saying even if you have a generic domain name, you can't use in the subdomain name the name of the venue, the artist, or event because it's too confusing. Now, I don't know. I don't think there's big enough companies wanting to fight it, but does that sound fair to you that they can create a law like that?
Sorry, who are you? Is that to Michael or to me?
I thought David had him, but
Yes.
both of you, of course.
Yeah. So it's a tough question. So if it's a brand that I understand, but if it's not a brand, so like say I want to have Taylor Swift dot cheaptickets.com and I'm selling Taylor Swift tickets on there. That's that's nominal fair use. How can the state law prevent me from doing that? But I can see where there's a lot of bad things happening, and I know Yelp does this, or some other food companies do this with like Grub Eats or something. They will create a subdomain for every restaurant and then bump them off. Like they'll rank on page one for everything, and so your restaurant never has a chance to rank on Google. So I think that's the problem we're trying to solve.
Yeah, that was a concern possibly in the future. What do you think, Jeff?
Yeah, I mean, the state can do that. I think they can restrict certain the creation of subdomains, but they what they can't do and they're not trying to do is mess with folder structures. So right, so subdomains appear to the left of the second level name, right, as a third level name essentially. But nothing will stop you from having cheaptickets.com/Taylor Swift, right? Because that's a folder structure. Folders are generally thought of in technology to indicate, something about the content there. So the fair use is on the offering the content. I'm not sure the fair use is the name itself. Um, but I think I think Colorado also has something proposed as well. So we'll see. I mean, they're trying to get at a real problem, which exists, which is these fraudulent ticket sales and um, people buying. these tickets thinking they're the original source, and then just losing all their money.
Yeah. So if you had United Center
So
discounttickets.com, that's a no. I have Prince tickets. Okay. So, and then I didn't get it just for Prince, although I love the guy. Is it wasn't just, it was Prince. It was like tickets for royalty. That was my idea, was, for the, for someone who wants the best seats. But according to these laws, you can't use a venue in the domain name or the subdomain name. Um, somebody with enough money could fight it and say and come up with some good defenses or reasons why to try to strike down this type of law. I'm not saying it'd be successful, but I could certainly see someone fighting it. And then, like you said, Jeff, these files, or I call them directory domains. That's what they're also known as. So yeah, apparently you could have crazytickets.com/Taylor, whatever, but you just can't have it to the left of the dot as a subdomain. And I think it's because some of the search or something, but yeah, it just doesn't seems weird. Seems weird for them to say you can't use this in a domain name, because like David said, hold on, there's going to be some, you know, federal fair use rights to it. So, but it's just interesting that they're trying to clean it. But the big deal is, okay, if it happened in the hospitality business too, you can't use Radisson St. Louis dot travelocity.com or something like that. So a lot of travel sites, hospitality sites do exactly that. You want rooms, and it's got in the subdomain, not the fucking directory domain or a file. So I don't know. I'm sure.
so
If I,
this law,
yeah,
looking at the one in Colorado, it's actually issued. It only supports ticket sellers, or it supports basically Ticketmaster and entrenches them. I think that's unfair. It should support the restaurants, which it's not doing at all. So that's a problem. So we know the Ticketmaster is probably lobbying for all this.
yeah, good point. I mean, so yeah, you'd think they'd want to protect the individual places, not a big entity like a directory or a big, the company, the main provider of tickets or rooms or whatever. All right, this last one we'll get through quick. It's fucking some Veo3.ai. And I had to cross out .com because I'm getting so confused. I'm glad that there's other extensions that are becoming popular and the world's adopting and understanding, but it's just going to be anything goes in the future. Basically, everybody, the younger generation, old people are just going to make mistakes. The younger generation needs to know, all right, what's the word? Where's the dot? And think about hacking names. Like when people use .es, that Spain CCTLD is a hack for, you know, a word that ends in es, because then you got to know, basically you got to know what's to the left of the dot, what's to the right of the dot. And I only like one dot. Okay, that's me. I'm like a one dot person. Okay, but then you got these cctld.com.au, or they said there's a .com.ai. The person that owns com.ai is offering subdomains. I'm like, this is getting good. But anyway, Veo3.ai was lost to Google in a UDRP because this Chinese registrant was wanting to, come up with their own product, some AI. I don't know. I can't recall the product, but the Chinese registrant
It's
was.
not actually their own product. It's a wrapper. So basically, what they've done, or the Chinese person did, is create a wrapper around Google's Veo product with an API service with no limits, and you just pay a monthly subscription fee of $49 a month. But this case was wrongly decided because um, they didn't even consider the Oki data defense, because it clearly says on the website that this is the authentic Google Veo service that you're getting with no limits, and you're just paying for it through the API service that they're facilitating. And in fact, last week there were a couple other UDRPs. So there was Veo3 API.ai taken, Veo3-AI.com taken, Veo-2.com taken, and Veo2.ai taken, and Veo2.zone taken. So these were all like recent. But these panelists did not consider the fact that this was an actual legitimate service using an API of Google. So Google's benefiting from this. And for the 3-member panel to not even consider the OK data test, I think is shameful.
Yeah. You know what's interesting, maybe, was Jeff. I want to ask you a question about the next round of GTLDs. There was a smart guy. I forget his name. He, I think he owned. Did he own PDF.ai? But anyway, he tried to register. He thought he was winning PDF.api over at Namecheap. He's like excited. It's not a ICANN extension. It was a handshake extension. So apparently, the long story short was he bid on this name. Namecheap refunded him, but then he did acquire it because it was a handshake name, and Namecheap offers these handshake names. They offer the extension, and you can register on. I wanted to ask you. So it's just confusing. The guy thought he was getting a name, and I guess Richard responded online like, "Hey, it should be pretty clear when it's a Web3 name, when it's a handshake extension. We don't try to confuse. We don't have this issue of confusion. Very seldom do people are confused because we're really clear on the website. But do you think .api will be allowed in the next round?
I have to look at the list of um, blocked names, but I don't believe API was blocked. Let me just do a quick, let's see. I mean, there's certainly name collision, but I think that, let's see, we have, like, I know dot example is one, ICANN is one. I'm just trying to find the other list, but I don't think dot PDF or API are blocked.
Geez, it seemed like PDF certainly would be because there's just so many companies use that not only publicly but internally, and it's just such a popular file extension. But okay, yeah. So I'm send me a link to that reserved list. You send me the other links to I have the root zone list, but the reserve because I'm thinking there's got to be. I know like .pvt or private and things like that. I mean I'm not looking at the list, but uh, I know that they reserved those last time. I'm assuming no one's going to be able to get them this time. It's going to be interesting. I can't wait to talk about this more and more and more. Got some great things going on with this next round. Certain folks that are applying, a lot of companies are considering applying, and then just a lot of interest from people who maybe can't apply themselves because it's a lot of money and a lot of responsibility, but talking about a TLD fund. Of course, I'm thinking about domain fund, TLD fund. There's all sorts of opportunity, but I love it's starting to heat up, certainly. And a lot of companies that are consulting, I've been speaking with, that consult their clients. And, Jeff and I have tldstrategies.com. If you're interested in applying, just go to tldstrategies.com, click, set an appointment, and Jeff and I will have a consultation with you about here's how we can help. But really, I like sharing with people, um, what they can expect. Let Jeff tell them, really all the requirements, but also budgeting initially the first year, first couple of years, first 5 years, because the work starts after you're successful in if you successfully, um, win a name. Basically, if you acquire a name or you're a TLD, starting your registry. But it's pretty exciting, and it's very exciting to know what are on people's minds. It's not always what you think because we hear about, .ape or .crypto or I remember they said .brave, and then of course Unstoppable with all their names that they offer on Web3 that they seem like they have interest in applying for the sort of popular ones like .wallet, and then I think of like .bitcoin. Some of them are going to certainly be contested, but there's just so many potential, I think, in my opinion, great extensions because we've seen the list of existing ones. People now are starting to like, tech and dev and things like that. So there's plenty to be, looking at the new stuff. Did you see that was .api on that list, Jeff?
Still looking.
Still looking. Okay. I'll get rolling. Oh, if you have any questions, by the way, we're going to get through our stuff pretty quick today. The cases, we do have 4 cases, but I think they're, some of them are, just in my opinion, pretty straightforward. So if you have a legal question or any comments, raise your hand, and then here when we're done reviewing these cases, we'll have a little legal conversation here. All right, the first case, and Jeff, of course, just chime in when you find out about that .api or any other extensions that are reserved that are interesting, because it is interesting. ICANN always has their reasons why they reserve a few of them. The first case we're going to go through today, I spelled it wrong on the outline. Now I corrected it, and and anyway, it's morganstanely.ai, morganstanely.ai. So it's Morgan Stanley misspelled .ai. Now, you all are probably aware of Morgan Stanley. I worked for them for a couple of years when they were Dean Witter, Morgan Stanley. That was how long ago it was. Brad, I'm bringing you up, but yeah, we're not, the questions at the end. I'm more like hearing Brad, and I like having conversations with Brad about, the music biz and old time biz, and I like the LS
Thank you,
too.
Todd.
Yeah, I mean, I hope I want to have a conversation with some of you, my
I'll,
old
I'll
friends,
wait
about
until
some
we're
bullshit.
done.
Yeah. Thanks. Yeah, we'll get through this pretty fast, and then we'll have a nice conversation. But anyway, so this first name was Morgan Stanley. And, okay, so Morgan Stanley, 80,000 employees. When I worked there wasn't that many. Why they got so many now? But versus Kyle Chura, it's a guy out of Michigan. But basically, he registered morganstanely.ai. And I'm not, why spoil it? But he said, I registered this because I'm developing a cartoon like fucking, Tom and Jerry, I guess, or something he was going to, broadcast on Facebook and YouTube. And he was going to call the cartoon Morgand with a D, Morgand. This was according to his response. And Stanley, but Stanley spelled correctly, not Stanley. So that's brought up because if you're going to do a cartoon characters, Morgand and Stanley, then why'd you get morganstanely.ai for the domain name? And that was one of the things that the complainant, Morgan Stanley, that, who was the complainant here, stated. But this case really didn't have a shot, in my opinion. I guess he could have come up with a better defense. But David, to you, what did you see in this case? This guy registers morganstanely.ai in early 2025. Did he have a shot at keeping this? Any defense that he could have made?
I don't think so. This guy's name is Kyle, and he's based in Michigan, and he's a marketer. And his LinkedIn profile says he's open to work, and he's been self-employed, I guess, for the last 20 some years. I don't, I can't think of anything legitimate out of that.
Yeah, and his excuse was really lame. I mean, for a couple reasons. Yeah, he said, "Oh, I'm doing a cartoon where the two character names are Morgand, Morgand, Stanley, Stanley. It was absurd because, first of all, he spelled he said his character name was Stanley, Stanley, but the domain he registered was Stanely. So he was doing a typo of his own character. I mean, that was just ridiculous. it, it just didn't jive. Um, but it goes to the point again, if you're going to make up an excuse and it's not, let's say it's your real intent to do that, you got to have proof. You got to have demonstrable preparations to use it prior to the dispute being filed or being aware of the dispute. And this was just kind of a lame attempt in a lot of different ways. It wasn't credible at all. And even if somehow this was the theory of how he wanted to use it, you can't really do that with famous marks that are so well known. So, from the start, this was just ridiculous in my opinion.
Yeah, this guy, he just really obviously wasn't believable. Paul just I call him DeCicco, DECICCO. He was the panelist, but he basically said, you know, what was that? Never reach. Oh, since this guy was, you brought it up, Jeff, but really thin defense. I'm gonna make I want to do this cartoon, and then I never reached out to anybody, and I think a lot of domainers feel that way. I didn't reach out to this big trademark holder. All right, well that's good. So you're smart enough not to reach out to them. That still doesn't release you from um, I would say liability, but it's basically it doesn't relieve you of your responsibilities of you know about them. We know you knew about Morgan Stanley. We know you basically came up with a misspelling, and um, let's see. It says respondent said, "Oh, he was open to good faith discussions to resolve it." So after all the bullshit, and Jeff, you might have mentioned it, he's like, "If you guys want to resolve this amicably, like basically give me something, but make an offer," and that just obviously didn't go over. The panel said, just because you held it passively, this is still going to be a transfer. So yeah, Paul decided 1, 2, 3. It was a transfer. He basically ruled obviously you have to rule all three prongs in favor of the complainant. And I was saying, it was also the panelists did mention finally, there was no substantial content on there. So the only way I could see that guy winning would be if he really did develop out a cartoon with Morgan and Stanley, and had it as sort of a, making fun of big finance or something, and still might have been a stretch, but maybe in a winning case for UDRP. And then, but anyway, so that was a transfer. Morganstanely.ai. If you're thinking about doing anything similar, why are you doing it? You better have a true, honest plan, and probably a satire site or something. But this next one, none of the cases today, in my opinion. The last one, Dirty Harry, is sort of interesting because I like the dissent. But the second case, SRO.com. Yeah, when I was young, it was in the 30s and 40s. SRO stood for standing room only because I was like watch HBO, and it was like a comic on there. And I remember when I got HBO, I was like in second grade, and I thought, man, they got movies at your house, home box office. And I'm like, oh, this is great. And then the dirty ones after 9 o'clock or 10 o'clock, just watching an R movie. It was
There
like,
was a movie provider before that. It was called WHT. It was, and I can't remember if that was like Warner Home Theater or something, but yeah, that was before HBO. So
yeah,
I know we're old.
I didn't remember. Yeah, cable. Yeah, cable TV. Like a cable come to your house, and you're like, cable. Then people would get up there and put these things onto splitters, but then you'd crack something to the one where you didn't subscribe, but people were stealing cable. And if it was anything worth getting in trouble for, that was it, cable. All right, so SRO.com was the domain name. This was originally registered in 1994. So it was a domain that was, registered way back. Now, the respondent in this case, who happens to be John Berg out of Norway, Sierra Remote Observation is the complainant. So that's their acronym, right? Sierra Remote. And just to let you know, so it's some company that provides these observatory telescopes. Of course, it's here in California. Some wise ass there. It says Fresno County. So they, since 2007, offered these. I guess you go to some place and you can. I don't know if the public can do it or they, provide data from these telescopes to businesses, whatever. But that's the complainant. So they said 2007, we've been, under the name SRO, and it's just, proven. You can see we've been doing bit, but they didn't provide any evidence of the size of their business or how well it was known. But they did finally get a registered trademark in 2022. But anyway, so they go after this guy, John Berg, who he acquired the name. He purchased it for 65,000 in 2017. So, like I said, registered in 1994. He picked it up for 65K in 2017. There's some interesting things with regards to the numbers. Do you want to share the numbers, David, about what the complainant offered for it, when they did that, and then how the respondent replied to him?
Oh, I think the offer was $500, and the the domain owner paid something like 65,000 for it years ago, and I think right now he wants 650,000. Is that correct?
Yep. And well, basically, the guy offered right $500 on in March 2023, and the guy that responded, his name like Dag Ford. I don't know if it was just a pseudonym. Is that how you say that? Responded 490,000 a few days later. So back then he said 490,000. Now you're right. It's got a price tag of 690,000, and of course the complainant is just mad. He said there was this respondent bought this name 10 years after our trademark, which I just told you they didn't get their trademark till 2022. So it was really misleading. 10 years after what he claims to be a common law mark that he didn't really provide any evidence of why it was a known mark and why he had common law rights to it. The respondent did respond in this case. You want to mention anything about how they responded, Jeff?
Yeah, this is the one I was thinking of, where he said that he had plans to use it in connection with. I'm trying to find the exact words because it was really kind of interesting. Um, well, first he argues that SRO could stand for a lot of different things, which is true, and I think that's the right argument, that he didn't target the complainant. It couldn't target the complainant because he was based in, I want to say, Norway. Yeah. And so there was no way that he could have heard of um, the complainant, especially because the complainant didn't even show any common law rights. So, that was good arguments by the respondent, and ultimately that's what won. But he said that he wanted to have it mean software refactoring and optimization. And he wanted to build a platform uh, for his activities as an IT professional that had portfolio and case studies, technical blogs and articles, being able to host project deliverables, having a contact point across different projects, etc. But just like the complainant didn't show anything supporting his common law rights, the respondent had nothing to show other than maybe his own declaration, um, and that's it, and his own defense. So again, it's really the nature for both complainants and respondents: put up or shut up, right? If you can't prove it, don't say it, because the only thing it's going to do is hurt your credibility. And the respondent didn't need it to win his case; he had the winning arguments already. So the panel basically said, found in favor, said that. And also the respondent sort of went out of his way to say, "I didn't buy it to sell it, like that's a bad thing." And the panel said, "Hey, it's okay if you bought it to sell it. That's fine. That's fine for the mark as long as you're not targeting the goodwill of the complainant, which you're not." So at the end of the day, um, the respondent won based on the fact that it's three letters. It could stand for a lot of different things. There's no showing of targeting. The complainant couldn't even show that it had rights before the domain was registered. And at the end of the day, this was a case that should never have been brought. And so Nick did find that this is a case of reverse domain name hijacking.
Yeah, and there are hundreds of trademark owners of the acronym SRO, which is common in Europe because it's the legal ending of a corporation. Instead of having Inc., they'll have SRO. So if I had SRO, I'd be offering corporation services in Europe.
I did not know that. So Nick Gardner said there's no bad faith registration, but Jeff, you brought up he was like skeptical of the respondent's plans. He was like, you didn't even need to say that, and plus you didn't show any evidence that you're really doing that. You just said it, and also the respondent didn't mention. This was what Nick brought up. Nick Gardner, the panelist, he didn't mention whether he was aware of the complainant or not. Not that, basically, and you were saying too about the respondent just he didn't need to add in some things that didn't help his argument. Now, this panelist said, don't worry about it. You're throwing a lot of stuff at the wall. what you did, the initial things do make sense. SRO, you didn't target the guy. It has several meanings. Let's leave it at that. And this person should have known, this company should have known, they don't have right to SRO.com. So Nick, saw through a lot of the crap and just said, this is reverse domain name hijacking, even though this response, the guy, made it a little murky by adding things in that weren't necessary. But, many times I was trying to think, must have been, I think he answered for himself, because this next case, so that was that was a complaint denied with RDNH. So that's how we like to see it as domain owners, to know you own a 3-letter like this and somebody comes after you. I certainly would get a lawyer to help. It's worth it. This name's worth a lot. And you would like this exact result. Deny the complaint, tell the complainant you've abused the system. Now get on. But, doesn't mean that they won't try to abuse the system in the future. This next case, movi.com. So that's the disputed domain name. movi.com, movie without the E on the end. This company that was the complainant in this case, MOVI LLC, filed this case against, originally it was just domain administration, but we've ended up finding out it's a company called ptbmedia.com, or I'm sorry, .com. I don't even know if they have the .com. But defended by Jason Schaefer, our friend who runs Esquire.com with Ari. Okay, so Jason defended this domain owner. The complainant has 2 trademarks with MOVI. They're in classes of clothing, specifically like hats and socks, and all I know is they got a couple trademarks under MOVI. So the complainant said, we got some trademarks. This respondent has no rights. And they had to bring up this have no rights because they have no relevant trademarks. And that's like sometimes people, entities get trademarks and they just think, man, I got a trademark. You don't have anything. And it's like most trademarks are common law marks. A lot of people have rights to things. They have to prove it, but they don't have it registered with the USPTO. A lot of people get a trademark and they'll put it up there. They'll post it for you to see. Look, I got a trademark. Well, congratulations. Who gives a shit? My point is, I shouldn't say who gives a shit, but it's good for you. Go use your mark, and there's several other classes. So great. You've shown that you're, using it in that class, because if it's just intent to use, you're in a holding pattern like an airplane that can't land at LAX. Okay, so this, what I didn't like about this case was the complainant said that the respondent registered the name to extort money from someone who has claim to it. So basically, this complainant didn't have a trademark when the domain was registered. Okay, it was registered back in 1995, but this respondent bought it in 2003. So the respondent still owned it for over 20 years. But since the complainant didn't have a trademark then, he basically just said, well, the guy bought it because he was planning to extort somebody who had rights to it. He's never had rights to it. And just ridiculous. Basically saying, I'm one of the people that has rights. So that's how he connected the dots, saying, we knew this guy registered the name to extort from somebody who has rights. I came along eventually, have rights to this, and that's why I'm in a good position to get this name, at least so they thought. But I won't take up all the facts of the case. Anything, Jeff, you want to go into? And then David, movi.com is the domain name. Jason Schaefer represented the domain owner.
Yeah, I think you have pretty much the facts nailed down. Well, I don't know if you want me to go into the decision. There's not much more in the way of facts, but the best thing about the decision for me is the statement that this case, and it doesn't happen often, but this panel found that the domain investor in this case has legitimate rights and interest in the domain name. because of being a domain name investor. That's huge, right? That doesn't happen very often. I mean, we knew they were going to be found not to have bad faith, right? That's the third element. But they, and two friends of the show, right? Alan Lindberry and Steve Levy were two of the three on the panel, and they found in favor of the respondent by finding um, that they have legitimate rights, which I think is great. It's not always done, and usually, and as I think we'll see, or we saw in the previous cases, if the respondent wins, they're just like, yeah, we don't have to look at the second element because of our decision on the third element. But here they do make that decision, and that's one to bookmark.
Yeah, David, do you recall what they said
Yeah,
about PPC links here?
well, none of them were infringing, but it did have PPC links on there, and that was part of the legitimate usage, and it's a widely accepted practice. And I've heard the exact opposite in many other decisions where, oh, it is a PPC page, that's bad faith. And so this is like they turn the tables on that. I like how they decided the UDRP perspectives on recent jurisprudence, saying that it's okay for domain investors to invest in names, in brandable names, is that they purchase for future sale so long as they are not targeting a particular trademark owner. And that's good. And they also cited Clash of Trademarks in there from Gerald Levine.
Yeah, the respondent had tens of thousands of domain names, and Jason made it clear that it's a legitimate business. This guy has tens of thousands of names. PPC links are a common industry practice, just like David said. Well, that is really what domain investors love to hear. That that's a legitimate business. Don't get mad at us for PPC links. We often have them on our pages because we partner with a parking company, but we don't decide on what links are there. Many times it's what agreements the parking company has with the service, whether it's Google or Yahoo or who's providing the links, and those change all the time. So it's not, Jason said it's not uncommon to have PPC links on your page, and it's not uncommon, it's very common to not have control over them. So don't hold that against my, and this was a complaint denied plus reverse domain name hijacking. So that's two in a row. And the third member of that panel was Sandra Franklin, who's, we see her, really deciding for brands a lot, for the complainants a lot. So in this case, she was overpowered by Alan and Steve, but basically she agreed too with them that this was should be a complaint denied. So the person, MOVI, the big defense was this is, a shortened name for movie. It's a great four-letter CVCV, but even before this respondent, this domain owner owned the name, it was being used by some other cinematic type company way back in 95 to 2003 because it's movie without the E, and companies liked using it as a brand for something related to that business. And and Jason made a great case here. It's nice to when it gets in the books as the complaint denied, and then the cherry on top, the RDNH. All right, our last case today, DirtyHarry.com, Warner Brothers versus Tom Hastings. Tech Hatch is his name. And Brett Lewis, so I was talking to Jason and John Berryhill, and it was about our thing we're going to be doing, Jeff. And I'm going to send you information on our mock trial, right? We're going to do at NamesCon, and we're Jason's representing the complainant. He's going to be doing just what he opposite of he did this last time. He's not representing the domain owner. He's representing the brand owner. And then John is representing the domain owner. And then Jeff and Karen Bernstein and Zach, but Zach may have to do a write-in if he doesn't show up. We're the three panelists. Okay, we are our three panelists. And if Zach can't make it, then I'll just tell you what his thoughts were on our case, and I'm going to be. But anyway, so I was talking with those two, and they brought up this Brett Lewis, who I don't know, but I know a lot of you guys know. They said, yeah, Brett will take the case because John and Jason were saying, it's an important, and we're going to bring it up at our panel at NamesCon, that you're a domain owner. There's some cases it's not, the lawyers don't want to defend. Your set of facts aren't there, basically not worth defending, okay, especially if you're in the wrong. But they said Brett Lewis, they said, well, Brett will take the case. No, he takes a lot of cases, like in this one, as a matter of fact. Do you know Brett? He's there in New York. Are you familiar with him? I'm sure you are, probably, right, Jeff?
Yeah, Brett, and another one that takes cases is Steve Reinhardt, who ends up being on the wrong side of some cases too, and I think we see that in the Dirty Harry one. But yeah,
Yeah, because we're domain owners. We want. I like the idea of going to these. Jeff is one of them. Zach is another, but of course John and Jason are two. Karen, I can give you a list. I think we still have them there at dnlshow.com. I'm sure we do. If one of those recommends that you don't fight it, good. They're just saving you some money. But you can find somebody who's, if you really, even if someone you like says, no, I don't think it's the case that I want to take, doesn't mean you still don't have rights to it. Well, we'll get to this case, dirtyharry.com. Okay, so Warner Brothers files this case against Tom Hastings. This guy runs Tech Hatch Company. And basically, Warner Brothers says, we've made 5 films with Dirty Harry. The first one was in 1971, titled Dirty Harry. We have, I think they actually have registered trademarks to it. Is that true, David? Do they have registered
No,
trademarks to this, or just
no,
no? Okay,
no
so they have
registered trademarks.
common law marks to it, but very well known. No one argued that. That was the 3-member panel here. Nick Smith was the chairman, and then Jerry Levine and Richard Hill were the wings. And I talked to Richard Hill last week. He was talking about this particular decision specifically on a call with Jerry about, why did Richard dissent. We'll get to that. So there's a 3-member panel, but basically, Dirty Harry, Warner Brothers says that's our fucking name. I mean, we got a trademark to it. The respondent offered the domain to Clint's lawyers for 100K. This was according to the complainants, because the respondents ended up saying, no, we offered it, we didn't give them a price, and we offered it to many others. But there was some discrepancy on, did they offer it after the UDRP was filed, and then that doesn't look good for the domain owner if you're offering it after the UDRP was filed. But this respondent says, no, I have emails to show it was before the UDRP was filed, and plus it was to no trademark owners. Clint Eastwood doesn't own the trademark to this. And anyway, the main defense was, this has become generic now. This is generic term. Dirty Harry, people use it all the time. Like, he's pulling a Dirty Harry. Like, basically he's reckless, or he's a vigilante, or some kind of thing like that. Basically, they're saying, so that was some of the stuff. I'll let which one of you guys wants to jump in and talk about the case, and then the dissent, anything you want to talk about. We're talking about the domain dirtyharry.com.
Yeah, so they used to have a trademark for Dirty Harry for slot machines, and then they stopped using it, and so they abandoned it in 2012. So presumably they stopped using it. I haven't heard of any Dirty Harry movie in the last 25 years, but other than that, I don't see how they got past stage 1, because hey, you don't have a valid trademark anywhere, and they didn't prove it. But if I go to Google Trends, there's still 165 searches, 165,000 searches a month for either Dirty Harry movie or Magnum Force or Bar and Grill, because there's Dirty Harry sunglasses, Dirty Harry lyrics, Dirty Harry handgun. So there is some notoriety with it, but does that give them a trademark? What do you think, Jeff?
so I thought, and I have to go back to the decision. I thought they also had one in Europe that they were relying on, the EU IPO, but I could be misremembering that. I'm just trying to scroll through
Oh
it.
yeah, you are right. They have a registration in the European Union where you don't have to show use.
Right. So that counts. And Again, this is another sort of put up or shut up. This is one where, the respondent says, I was going to use it to mean, uh, just like Dirty Harry was cleaned up the streets of San Francisco, I think it was San Francisco. Um, I'm going to clean up the street or clean up the housing market for so and so. And, okay, not bad idea, but show us something that you've done other than just your own kind of statement that that's what you want to do. The other thing is, if you're in a position to argue genericness of a mark in a UDRP, it's not the place to do it, right? A panelist usually, or the dissent notwithstanding, um, a panelist will not consider genericness of a mark, um, if if that's raised by the respondent. The only consideration that that's done, that needs to be done by a court or by the trademark office through its own procedures, but not through a UDRP, which requires a ton of evidence. Um, and so the dissent basically says, well, the claim was raised, and therefore we should have just dismissed it and said it needs to be in a court. But I agree here with the majority, which says, look, it's clear that um, they still have rights according to the trademark, and it's clear that the respondent was playing off of those rights because he even compared it to the Dirty Harry in the movies. And when you do that, when you have suspicious activity like offering it for sale after the complaint's filed, which I know he disputes, but um, the majority believe that he did that. uh, those things combined just made it a very difficult case for the respondent. And ultimately, I do agree with the decision, that in favor of the complainant to transfer the name. Um, Again, it kind of the theme of you put up or shut up, right? If you're gonna argue you're using it for a purpose, then you need to have things that prove that you began using it for that purpose. You can't just make a statement. Now, the one area that genericness is sort of addressed in other decisions is if you have truly a dictionary word, which Dirty Harry is not really a dictionary word, though the respondent claims it's in some slang dictionary. But a true dictionary word, if you're using the domain name in its generic sense, then yes, that is considered, by panelists, but not if you're trying. What's not considered by panelists is if you're trying to take an otherwise legitimate trademark and saying that that trademark itself is generic. And so I agree with the majority.
Yeah, so there was three panelists: Nick Smith, Jerry Levine, Richard Hill. Nick and Jerry said one, yep, there was, like David and I remembered that too, looking at it. There was that European trademark. So yeah, they do have a trademark, easy to prove with the registration in Europe, that this guy really didn't have legitimate use. They just felt that Warner Brothers made the case that the person didn't have legitimate use, wasn't known by it. He did not provide any evidence that he was going to do exactly that real estate flipping idea that he mentioned. Even though he was a real estate agent and he had done, as a developer, done things in the past, for this particular idea, the majority of the panel felt like, you're just saying that. I mean, basically, it's a cool idea that relates to your current business, your experience, but you didn't provide us any evidence to show you were actually doing that. And the majority accepted, the that the mark was not generic. Not, it was also basically, like Jeff said, I think what made the mistake was, even though Clint Eastwood and his attorneys didn't have rights to the mark, you're going towards people that had relationship to the mark in a way. He was the star of the film. So did you buy this? Basically, the majority did say, yeah, you registered it in bad faith. Your intention was to, you know, to sell it to. You probably would have liked to have sold to the market holder. But anyway, so I did like Richard's dissent, basically just saying that he thought it's been a long time. Old folks know, hey, Dirty Harry, it's Clint Eastwood, but younger people, I mean, think there hasn't been a movie in a long time, so that Dirty Harry certainly. I don't know. I like Debbie Harry more than Dirty Harry. All right, so that's going to be it for today, other than Bradley's back here. And Bradley had a comment or question about some legal issues related to domain names. Hey, Brad, what's going on?
Hi. Thank you, Todd. Thank you, Jeff. Thank you, David. Just you guys do such a wonderful job. And I just want to commend you and how valuable it is to me and the domain space community. My question is about a 4-letter .ai, lcsw.ai. What is that a protectable name?
Well, when I Google it, I get an AI overview saying it stands for licensed clinical social worker.
Right.
So, and what's the issue? Is there a company with that? Is there a trademark with that?
There's a lot of trademarks with that. And they usually do, deal with some kind of mental health issues.
Okay, so yeah, I was seeing that there's a couple of ones like Anchester, LCSW. It's pending. There's probably an issue with it. There is one registered, Senior Living Behavioral Health, LCSW. Let me see if there's a disclaimer, because that will tell you right away. I don't see disclaimer for LCSW. They do disclaim behavioral health and PLLC. So it's not determinative though. I would say that if it's used in its generic sense for licensed clinical for social worker, then I think you should be fine. Yeah.
Now, it is. I mean, I think the known trademark is for licensed clinical social work. Okay, so I mean, and there's other uses, and I could think of other uses for it. My question and why I thought it was valuable and what I would like to see to do with it, maybe not. I didn't think about it until after the fact, which is an issue with a lot of my, I hand registered the name, and if it's hand registered, my perception is if it was trademarkable, someone who had the trademark would have gotten it. That was a misconception, I assume. But I have a interest in this growing trend of AI psychosis and how the human nature to develop connections with other people, and if they don't get it with other people, just to get conversational feedback from a bot is becoming more and more rampant. And I was wondering if there's a way that I could use this for that.
Well, I'll tell you, there is a trademark registration for Cooperative Balance LCSW. They have a disclaimer for LCSW, and their services are counseling in the field of mental health and wellness. So the fact that they've disclaimed it for counseling tells me that you can use it. What do you think, Jeff? Yeah, maybe.
If you are talking, you're on.
Maybe you
Yeah,
can answer the
I
next
was
question.
sorry. I was looking up and I couldn't get back to my screen. Um, Look, it's hard to just make that kind of assessment um, just off the top because I know you read the trademark. Yes, it disclaims counseling, the word counseling as part of the mark, but it's a I couldn't just. I'm reluctant to give an opinion. Let's put it that way.
Yeah, there's another trademark, Cooperative Balance LCSW, that's registered, and that one actually disclaims LCSW.
So are you saying if I used it to make a bot that has ethical, moral standards regarding the conversation, and i.e., like some new cases have just brought up about the AI encouraging a teenager to commit suicide, and then another and one where a gentleman killed his mom and himself because the AI said to him, "Don't trust your mother. She has poisoned your air freshener in your car." This is what the AI came back with.
So one big thought here is license means licensed by a state. And if it's not, if this app is not licensed or approved by the state licensing board, then I think you'd be committing some sort of state infraction, which is probably not good. So you want to check
Not
that
good.
out.
No, I have no. But how about if I use the acronym for something like love, care, safe, wisdom?
It sounds very contrived, but I don't know.
Well, it is contrived. I'm just, and I'm not, stuck on this. I like the intellectual, you know, challenge, and I'm just, not trying to be an LCSW, but because of the word license. So, in other words, from Jeff and you, it's a big stretch. Is that your perception?
Yeah, I would just sell it to a bigger organization that actually uses LCSW in their name. And there are 11,700 of them registered on Open Corporate. So yeah, start doing outbound and you can probably get maybe 100,000 for the name.
Okay.
Brad's like, "Fuck, thanks, David. You might already get
Yeah.
100,000 for the name." Well, first of all, of course, you can use it for Laurel Canyon Softball Weekly. I don't know. You can
I like that one.
you can use or legal classes. Um, I was trying to think of something to David, but anyway,
But it's not, but if you ever got a UDRP, again, it's the put up or shut up, right? You better be using it in connection with that and not just have, tucked away as your excuse or your intention after you get, if you were to get a complaint, right?
Yes, that's
So
total correct. I mean, and a thing that was brought up earlier with this Morgan Stanley, right? If the guy had actually created a comic strip and had, some documented evidence, that would have been a little different than just coming up with something.
and
Yeah, like it could also be used for let's create something wild. So if I did an art thing on it, would that be trying too hard?
no, if you actually did it, it doesn't matter. I mean, because the truth is, when you said LCSW, I can tell you 99% of the people in here were like, we don't know. I don't know. That could stand for anything. And if I had it in my portfolio and yours is a .ai, I'd have a price on. I think no one. I registered it because it was 4 letters, and then if I searched it and I saw, and it is predominantly talking about social work, these licenses, I think, okay, that's going to be one use. I didn't know about it. It's just so happens that it's popular in that field, but there's still that first thing that you said, love, sex, whatever you said anyway. I forget.
Love, care,
Love,
safe,
care. Okay.
wisdom.
Love, care, sex worker. Is that what you said? Okay. So
Yes.
the point
Love,
is,
care, sex
well, you
worker.
could, if you started, basically just add some content. So if you did, hey, this is the name of my podcast, and you did a few of them, but right, they'll try to force you into, you better develop it out now even farther. 2 episodes, that's not enough. But the thing is, if you steered very clear of anything related to this licensed care, these social workers, whatever it is, no, I think a regular panelist is going to say, I didn't know about it either. When you registered it, if you're saying you weren't familiar with what LCSW means, I think it's certainly believable, because it's just every acronym out there. People think, well, that's really popular. Yeah, it's popular if you're in that field, I guess. But this is not, a popular acronym. But even though it is, used, and we see in the search, so you definitely can use it in other areas. That's just, my opinion by it. I know it's got to be true. If you had no connection to that field and you weren't using even the same anything similar to their acronym, I don't see how that wouldn't be certainly fair. Go ahead, Dave.
Okay.
So there are 36,900 searches a month in the US for LCSW, and 2,100 of them are for salary and 1,800 for jobs near me. So there is a definite usage for this. A lot of EDU institutions are paying a lot of Google ad dollars to actually rank or to get placed for LCSW in the SERPs and display marketing. So if you had Google AdSense on your site, probably make maybe 10 to 15,000 a month if you could actually get your site to rank. But yeah, like Simmons.edu, WaldenU.edu, these schools are spending a lot of money. Even Baylor's spending money on this. So yeah, it
That
almost
was my first thought was a 4-letter .ai. I have one other one, but you know what I mean? That's what, and then that's what I bought it for. I didn't do the extra deep thinking. And that's why I appreciate your feedback. And it was after the fact that I saw that it was really, dealing with the licensed clinical social work. So,
The other one,
I even,
the .com, Brett, sorry to catch up, is for, looks like it's a land or domain or, inquire about this. But David's saying it's worth 100 dimes. Anyway, anybody in the room listening who's not real familiar with domain investing thinks, well, that's easy. David's an attorney. That's worth 100,000. You'll probably get 100,000 for that. But no, I hope you do. And I do like the idea of if there's that many folks that are using, have trademarks for it or use it in their titles, of course, yeah, reach out to multiples, and that's a way to avoid targeting. You're reaching out to, and you put that in your email. I'm reaching out to the hundreds, if not thousands, of people that I think could benefit, companies that could benefit from this. And there was something else I wanted to mention about that. I mean, because I think,
yeah. So, and could
I
I say,
promise. Yeah.
I bought this not knowing, and I thought you might be interested in the
No.
outbound.
You
What I
can
would do
know.
is just create an educational portal for training LCSWs, and that's what the schools would pay for. And I think if you were to start making that educational portal using online courses that are free, like you can get Creative Commons licenses from edx.org to host some of their videos and courses, you can really bank on this domain name
Well,
using WordPress and
well,
AdSense.
well. Thank you. We'll discuss it further in private, I
Yeah.
guess.
Hey,
I don't know.
after registering this for a completely separate use, I now understand that there are thousands of companies that may have, you know, a better a use for it as well. But anyway, you could do something like that, Bradley, where you're saying,
That's excellent,
yeah,
Todd.
oh,
Those
it's
are great
excellent.
words.
Yeah,
Thank you very much.
no, thanks for always being here, and thanks to everybody else for showing up. We appreciate it. So, domain name law, you guys know it's somewhat interesting, but legal issues. If you have any questions about domain name law, bring them here next Tuesday. We're going to have 3 cases that we're going to review next week. Try to get through them fast. Have some, try to get through these, our stuff in 60 minutes. And then if there's no audience participation or questions or comments, then we can get out early, but try to spend the last 20 to 30 minutes talking about real things that are happening. And this doesn't have to be a UDRP. It can just be, hey, I got this cease and desist letter. Not, and the lawyers here aren't going to give you specific advice. And of course, I'm not an attorney. I just went to law school. So the point is, it's fun to talk about, here's situations I've confronted with, or I know people have experienced. How are there several different ways you can handle this type of stuff, and how do you respond, or should you respond? But anyway, any legal questions or issues, this is the place to bring them for domain name law. And then of course on Thursday, I do a room with Josh Reason. It's called DNX Show. It's just about domain name investing. We started this Thursday like we do every Thursday, 10 a.m. Pacific, 1 p.m. Eastern. I got tons and tons of topics to go over this week. I mean, there's so much going on in the domain space. I mean, basically, people just love to talk about domain investing. So that's the place to be to talk about strategies, techniques. Basically, how can you make money buying and selling domain names? That's the place to be. So hope to see some of you there on Thursday. But until then, have a great week ahead, and talk to you soon. Hopefully, somebody will put on some rooms before Thursday so I can pop in and enjoy it myself. Thank you so much. Have a good day wherever you're at.
Thank you, Todd. Thank you, David. Thank you, Jeff.